A little-known Supreme Court order is now at the center of a national storm over racial profiling, immigration raids, and the limits of federal power. During a House Judiciary hearing, Congressman Hank Johnson of Georgia pressed Deepinder Mayell, the executive director of the ACLU of Minnesota, about how a recent decision involving Justice Brett Kavanaugh may be shaping what communities are experiencing on the ground today.
I'm now going to go to members of the House Judiciary Committee, and we're going to start with Representative Hank Johnson from Georgia.
Thank you, Representative Jayapal, and I thank you and Representative Omar for holding this very important hearing. And I want to thank all of the people for coming out today. I want to thank our panelists for their testimony. I am in awe of the courage, the unity, the fortitude to resist, and the warmth of the hearts of the people of Minnesota. You set an example for the nation and the world. Mr. Mayell, I want to talk a little bit about how the United States Supreme Court laid the foundation for what is happening in Minnesota with respect to Fourth Amendment issues when it ruled in the on the shadow docket, Noem versus Vasquez Perdomo, a opinion shadow docket, which held that apparent ethnicity could be a relevant factor in federal agents' decision to stop and question someone about their status. How did that lay the predicate for the what's going on in Minneapolis and St. Paul, Minnesota right now?
Thank you, and thank you for the question. And I just also want to say a quick thank you to, I know everyone who has come out here. I know you all are showing up at detention sites, at Know Your Rights presentations, and at hearings with immigration courts. And I thank you for all of your courage and all you are doing. It really is impactful, and we see it all. The Perdomo case, thank you for bringing that up. I know a lot has been made of this Justice Kavanaugh's concurring opinion. It's important to note that this was on a shadow docket. It was a temporary order pausing a lower court injunction. It does not create new precedent or overturn prior cases limiting racial profiling. The decision is with no legal rationale from the majority of the court, and that constitutional protections remain in place even though this decision should be, this opinion should be criticized for what it was projecting.
Well, I mean, it seems like it opened the floodgates for racial profiling in this town. Isn't that correct?
Well, so, I would say that the opinion certainly deserves to be criticized, and there was a great deal of racial.
Anytime you issue a shadow docket decision and an opinion on the merits of the case before it's actually been briefed and argued before the court, and you lay down such a principle like Kavanaugh laid down, it has given rise to what we call Kavanaugh stops. And it's taken place not just in Minneapolis, St. Paul, but it's starting to take place around the country now. Of course, the case arose in California, Los Angeles. But let me move on from there. These Kavanaugh stops have not been limited to just jacking up Somali-looking people. It's gotten much broader than that. Would you comment, Chief McCarthy?
I'm afraid I can't. I've never heard that statement before about Kavanaugh stops. But in Minnesota, all law enforcement officers in Minnesota are prohibited from using race as a determining factor for any sort of stop or detaining someone.
Thank you. I yield back.
Thank you, Mr. Johnson. I'm now going to go to members of the House Judiciary and the Immigration Subcommittee, the members that serve with me on the subcommittee, and many have been at every hearing we've done. We'll start with
Johnson opened with an emotional acknowledgement of the people of Minnesota, praising their courage and unity in the face of escalating ICE operations. But he quickly turned to the legal foundation behind those actions, pointing to the case Pedro Vasquez Perdomo versus Kristi Noem, a dispute the Supreme Court handled through its shadow docket rather than through a full public hearing. The congressman argued that Justice Kavanaugh's concurring opinion appeared to suggest that a person's apparent ethnicity could be considered by federal agents when deciding whether to stop and question them about immigration status. To Johnson, that language looked like an invitation to racial profiling dressed up as legal reasoning. He asked directly whether that opinion had laid the groundwork for the aggressive tactics now being reported in Minneapolis and St. Paul. Mayell responded with careful precision. He explained that the order was temporary and did not technically create new precedent or overturn earlier rulings that prohibit racial profiling. Constitutional protections, he said, still remain in place. But he also acknowledged that the opinion sent a troubling signal, especially because it was issued without full briefing or argument. Shadow docket decisions, he warned, often shape behavior even when they are not formal law. Johnson pushed back, saying that on the streets, the impact feels very real. He argued that the opinion effectively opened floodgates, encouraging what activists have begun calling Kavanaugh-style stops, encounters where people are questioned primarily because of how they look. According to the congressman, those stops are no longer limited to any single community and are beginning to spread across the country. Police Chief McCarthy, who was also on the panel, offered a different perspective. He stated that in Minnesota, local law enforcement officers are strictly prohibited from using race as a factor in any stop or detention. He added that he had never even heard the term Kavanaugh stop before the hearing, highlighting the gap between federal immigration practices and traditional policing standards. The exchange exposed a deeper conflict playing out nationwide. On one side are communities and civil rights groups who believe federal agents have been emboldened to treat ethnicity as suspicion. On the other are local police departments that insist their own rules forbid such behavior, creating confusion about who is accountable when federal and local authorities operate side by side. What makes this debate so significant is the way the Supreme Court's shadow docket has quietly reshaped the landscape. These emergency orders often arrive without explanation, yet they influence how agencies interpret their power. For ordinary people confronted by armed officers, the distinction between temporary order and formal precedent means very little. What they experience is the knock on the door, the stop on the street, the question about their right to belong. Johnson ended his remarks by reminding the room that constitutional rights are not theoretical. They determine whether a mother feels safe driving her children to school, whether a worker can walk to his job without fear, whether Americans of color are treated as citizens or suspects. The hearing made clear that the battle over those rights is moving from courtrooms into neighborhoods across the country. If you want clear, factual breakdowns of how these legal decisions affect real lives, subscribe to the channel so you never miss our coverage. We follow the hearings, read the rulings, and explain what they actually mean for you and your community.